Jim's normally a regular, but he emailed and said, but he wanted to ask this question about, my wife and I are both have wills. Our Christian super pensions are reversionary to each other. In the event of us both not surviving, I guess dying, does our Christian super pension automatically become part of our estate, in which case it would become an inheritance for our children and other recipients? And secondly, what would the tax implication for them be for them? Really good question. In the case of a reversionary beneficiary, that just means that if either of Jim or his wife died, the Christian super pension would just default to the other person, so it would automatically start paying to the other person. In the event that both people died, in the event that one died, both pensions would then be paid to the surviving spouse. Now, if that one spouse is, because the reversionary, the dead spouse, isn't able to receive the reversionary pension of the other spouse, it'll be important for them to set up a nomination again. So you can, once the reversionary has cleared, then set up another binding nomination to direct your pension somewhere else. And generally we would make that, if you've not got a financially dependent person, we generally suggest it goes to your estate. So that's what you would do there. If you both died, for example, at the same time in a car accident or something along those lines, then it would be up to Christian Super to determine where the funds would go. And most likely that would be to the estate or directly to beneficiaries, for your children, for example. But Christian Super would need to work out, as a trustee, would need to work out how to direct those funds. In terms of the tax implications, it depends on the components of the fund, and also in the event that we both die and the money, the superannuation money in your pensions goes to your adult children and they're not financially dependent, then they, on the taxed components of your fund, they'll potentially pay 16.5% tax on that money. So that's the tax implication of going to a non-financial dependent. 16.5% on the taxable component, not the tax-free component. If it goes to a financial dependent, so if one of you dies and it goes to the other, for example, then there's no tax implication there because you're a financial dependent. So hopefully that answers your question, Jim.